Assalamu alaikum warahmatullahi ta'ala wabarakatuh. This is my first attempt to have regular video series lectures over relevant issues that pertain to the Muslim community in India in particular. And today let me discuss very important and hotly contested topic of religious morality versus constitutional morality, and what about the protection given to the religious ethics guaranteed under Article 25 of the Constitution. Now, this topic is very highly relevant today in the sense that after the three verdicts that recently pronounced by Supreme Court in the last 1 month, that is so crucial for the future course of India. Let me first bring to your attention the cases or the Supreme Court verdicts on which I will be dealing the topic of religious morality vs constitutional morality. The first case is triple talaq verdict, and another one Shabarimala verdict, and the last adultery law IPC, that means IPC 497. Now, let me come to the point that the religious morality, then let me first define what is religious morality and then constitutional morality, and then go to the constitution necessities when there is ostensible contradiction between the two, which will prevail, and how this axiom will affect the religious functioning and ethics in the future life of Indian Muslims. So let me first clarify. Religious morality means the morality prescribed by the religion, or that demand morality or ethical code demanded by the religion from its followers or practicing people. For example, in the case of triple talaq, religion says that the number will be considered. That means, in broad terms, the number of one pronounced the talaq, if it is 1, 2, 3, or more than 3, will be considered as part of the talaq. So, if one pronounced 3 talaq at one go, it will be considered talaqul baya. That means that cannot be recovered. Then that is the religious morality, the morality that religion demands from the practitioner, and it is sometimes divinely revealed, or that was codified by eminent erudite scholars. Then what is constitutional morality? Constitutional morality means the morality demanded by the constitution. For example, the fundamental right. Take me the fundamental rights from Article 12 to Article 35. This portion deals, the part 3 deals with the fundamental rights of India, and these are enshrined in the constitution, and every one of Indian citizen, regardless of caste or race or religion, place of birth, gender, is entitled to these kinds of rights. Then constitutional morality, the morality or the ethics demanded by the constitution. For example, gender equality is the morality demanded by the constitution, and the constitution says the biological discrimination, just like in the case of Shabarimala, is not acceptable, or that is ultra-wise unconstitutional when we take into consideration the constitutional morality principle. Then this is the topic, religious morality vs constitutional morality. Religion says something else and constitution says something else, and this battle goes on, and this will continue, and it will have a wider, far-flung impact in the future life also. Then when we go deeper into the topic, let me come clear on the point in the as part of part 3 of Indian Constitution, or the part that deals with the fundamental rights. Article 13 says that laws inconsistent with or in derogation of fundamental rights will be automatically, the word or this adjective should be emphasized upon, or laws inconsistent with or in derogation of fundamental rights will be automatically unconstitutional. For example, any laws that is in violation of constitutional morality or any ethics demanded by the constitution will be automatically unconstitutional, or in legal term ultra-vires. Ultra-vires means unconstitutional. So fatwas, and in explanation of that that constitutional provision, it says that any custom, any fatwa, or any urf means the practicing style of the Muslim Ummah, and anything or traditions that comes against the constitution will be automatically invalid, or will be against the unconstitutional. And then now when we take the case of triple talaq, with triple talaq, according to the Muslim belief, or the Muslim body of belief says that the number will be considered for the talaq purposes or divorce purposes, and if the husband pronounce one, two, three, or more than that, the number will be taken for the consideration. But the constitution says that, and the last verdict on the triple talaq, it says that it is unconstitutional. Then there is a contradiction or conflict, a turf war between religious morality and constitutional morality. And this battle is not limited not only to the Muslim Ummah, but it goes on and it affects the Hindu community, Christian community, and all other community, and Jain community also. Then here, what could we do? And take me one more example, Shabarimala issue. Shabarimala issue, religion says that any young Hindu woman, not Hindu woman, any young woman between the ages of 10 and 50 are not allowed to enter the Shabarimala precinct on the premise that they are impure due to the menstruation. And anyone who want to enter the Ayyappa Sannidhanam or Ayyappa precinct, he should take the rosa, or take the fast of 41 days, and then after purifying the body of through the 41 days fast, only he can, or only he she can enter the precinct, Shabarimala precinct at Pamba. And according to the biological structure of the female, and at the time between 10 to 15, at the time of fertilization, or at the time of menstruation, and the menstruation is a cycle that will continue once in a month, so she cannot hold 41 days fast, so she is impure. And the Ayyappa, who is the idol or an enshrined deity of the Shabarimala, is Nashtiga Brahmachari, that means eternal celibate. So is not advised for the woman, not advised, it is banned for young woman between the age bracket of 10 to 15 to come to the Shabarimala. Then here religion says that this is a religious concept, that and due to the menstruation woman should not come here. But the constitution says that no, there is article 14 of fundamental rights in the part 3 says that prohibition of discrimination on the basis of gender, caste, religion, sex, and place of birth. 5 kind of prohibition are given them. And the prohibition of gender discrimination is well mannered here, and it is well established. So when the religious says that the Ayyappa, according to Hindu laws or the Ayyappa Dharmasena, they should not be given the entrance, but the constitution says that constitutional morality demands they should be given the entrance or permission to enter the Sanctus Sanctorum or the Ayyappa Sannidhanam. And just like in the triple talaq verdict, and here comes that religion says that the number will be considered, and the constitution says that is against the constitution because there is no gender equality. And just like an adultery law that was recently invalidated by the Supreme Court, IPC 497, and that says the fornication of the married woman with someone else. And especially this adultery law was premised upon the axiom the woman is a chattel. Chattel means the article of the husband, and the court observed that this is against the constitutional premise of gender equality that is guaranteed in Article 14 and Article 21 once again. So this is against the constitutional ethics. These are unconstitutional and not to be practiced by Indian citizens who abide by the law of the land. Now the problem here, when in the triple talaq verdict, the Supreme Court says, or the petitioner for the invalidation of the triple talaq approached the Supreme Court saying that this triple talaq infringed the fundamental rights given under the article of 14, under the article of 17, and under article of 21. And the court, after examining the various law points here, and gave the pronouncement, okay, it's against the constitution, and the triple talaq should not be practiced here. And now the government considering making a civil offense a criminal offense. That is some part of political game. We are not discussing that one. And just like in Shabarimala, woman approached the Supreme Court saying that this is against the gender discrimination, and it violates the gender equality promoted by the constitution. And this happens here. Now what could we do? There is imperceptible turf war between the religious morality and constitutional morality. Then what is the solution? And later in the coming cases of Nikah Halala and entrance to the Vaishnavi temples and Sandhara cases of Jain and permitting in a female preachers in the secure religion, and this has a far-flung, wide-reaching effect on all people who believe in some kind of religion. Then, what is a possible solution? Yeah, and when religion says something, constitution says something, and there is contradiction, then what will happen? And it's according to Article 14. Whenever there is a contradiction between religious morality and constitutional morality, it is very evident, or it is evident like the sunshine, or and it is crystal clear, and that is the constitution that will prevail upon. Now, the another matter here. Now, to absolve the Supreme Court of the blame of interfering in the religious reform, the Supreme Court has introduced a new kind of innovation in the Indian judicial realm, that is essentiality of religious practice. Then now what we are discussing, when there is a discrimination or a contradiction between religious morality and constitutional morality, then to solve the problems amicably, Supreme Court has introduced an innovative approach that is called essentiality of religious practices, and this was first pronounced by Supreme Court in 2008 in the Muhammad Zubair vs Union of India case. The case is this, that he was a Muslim serving in the Air Force, Indian Air Force, and he was disbanded from the armed force because he sported a beard. Then he approached the court, and the court said there is a concept, essentiality of religion, and this concept was later adopted by various countries of US, Indonesia, Malaysia, and various other countries. Then when a religious issue comes into the court's approach, or when it comes into the court's consideration, they will look whether this part is an integral part of religion, or does this provision of the religion is an essential integral part of that religion. For example, the just like one, the prayer, 5 day prayer is an essential part of religion. Then so Supreme Court could not interfere in that one, and all other things which are not the essential part of the religion are subject to the judicial intervention, or subject to the judicial activism, and for the comfort of the reform of the community, court can interfere in the issues which are not come under the bracket of essentiality of religious practices. Then let me make it clear here, it's not what makes into the essentiality of religious practice, and what does not, is not crystal clear and is not well defined by the courts. So there is a lot of ambiguity around surrounding this topic. Then let me conclude saying that, and this debate of constitution vs religion will be going on until the Supreme Court or the legal luminaries of this nation find amicable solution how to fix the basic part of the religion which cannot be touched upon by any institution, whether it is judicial, whether it is administrative, legislative, and what are the peripheral portions of the religion which could be reformed or which could be modified according to the whims and fancies of the societies. Then that's all. And in the Shabarimala case, this happened, and the court said, well, okay, that will be the tradition, but constitution demands this ethics. That means the lack of discrimination, prohibition of discrimination on the basis of gender, and this discussion will be going on, and the solution lies here until no solution until court defines very categorically what is essentiality of religious practices. That's all. Thank you. Goodbye.